of you actually. I am lucky enough to be one of the co-chairs of the early career physician section. I was technically the resident chair, with us hosting these events for residents. Honestly, I'm very excited to discuss this topic with you because when I came in as a first year resident, I did not read my employment contract, right? All of us were just trying to start residency. I signed it, I didn't even look at it. But going forward, when you look for that first attending job, we realize that the contract actually becomes one of the most important things in our lives and is actually a major player in your long-term personal and professional satisfaction and your career longevity. So because of that, I'm really thankful tonight to be able to welcome Anisa Kelley to join us in giving us her expertise. She specializes in representing healthcare providers in professional regulatory board matters, including disciplinary investigations, credentialing, risk management issues, healthcare investigations, and she represents healthcare providers in a wide range of state and federal investigations and practice issues. So she has represented hundreds of healthcare providers in medical practice cases in Virginia and DC, and has a solo practice here in Northern Virginia. So Anisa, thank you for being here with us tonight.
Thanks for having me. All right, so we'll go ahead and get started. Tonight, obviously, we are going to discuss physician employment agreements. The presentation is meant to be educational. It doesn't represent legal advice. As we'll talk about, much of that is on a case-to-case basis. So as Dr. Wu alluded to, when you have an employment agreement or an offer, you ought to have that evaluated, as it relates to you in the jurisdiction you're in. So tonight is just educational information. Okay, first we're going to talk about some contract basics. One thing, the employment agreement should include all of the material or important terms, meaning anything that you believe is important, as Dr. Wu mentioned, to your professional and personal life ought to be included there. So if someone mentioned something to you by phone, sent you an email about it, if it's important to you, it ought to be in the written agreement. Most agreements will cover these issues: who the parties are, what the position and duties are, what the compensation model looks like, the duration of the contract, how it will be terminated for cause, not for cause, what kind of notice you owe. Lots of employment agreements have restrictive covenants, either about competition or solicitation of patients or employees. That's pretty common. They usually cover dispute resolution. Some will require you to do mediation or arbitration rather than litigation. Some of my least favorites now require you to waive a jury trial. As a human myself, I would never waive a jury trial in my own employment agreement, but lots of physicians feel they need to or sign on. But that's a common request of employers. Most of the agreements state it is the complete agreement. So as I said, if there was something else promised to you or referred to, you ought to have it referenced in the agreement itself. The other thing I often see is the agreement references other documents that are often not provided to the physician. So it might say, you need to comply with our set of policy or a handbook. And when I ask the physician, they've usually never seen it. So if there are other documents referenced, you want to obviously know what they are and have an opportunity to review them. One last caveat there for me is avoid making assumptions. So again, if it's important to you and it's an issue that you want to be addressed, it should be included in the document.
And along with what Anisa said with referring to other documents, sometimes you can get a letter of intent sent to you, which is not the same thing as a contract. So they might talk about similar things to a contract, like your compensation. But you should be careful about signing it because sometimes they're not binding and sometimes they are. So when you really actually talk about signing a document, you want to make sure you're looking at a finalized contract.
So one of the next things we'll talk about is who the employer is. And that seems pretty basic, but as healthcare evolves, that is changing as well. So you want to know, whether it's a private practice, who owns it, whether it's the hospital or university, and sometimes there are overlapping duties and compensation. So that's one of the reasons I mention it, is if some of your compensation is going to come from your group, but you also, teach a class or have rounding obligations. You want to be clear on who employs you for what piece and who you owe the duty to, who is compensating you. I mentioned successors and assignment because that often comes up in an agreement. What it usually means is the employer often can assign their duties to someone else. They might sell, they might merge, and you usually cannot assign your duties. You're the person who has to perform them. One of the things to look for in your employment agreement is what does happen if your employer does assign their rights. So if they are bought out, if they merge with someone, do you automatically become employed by the new entity, or is it renegotiated? And so that's one reason I mention it there, is to kind of understand that. Again, with healthcare being sort of volatile and evolving now, you want to know what would happen if those circumstances change.
So as you can see from figure 1, there's generally speaking about 4 practice options you can see yourself going into, like the owner of a sole practice within a group practice, or the employee of a group practice, hospital, or healthcare system, or of an academic institution. So as an employee of a group, you want to know if it's owned by physicians or a private equity group, because now, again, with healthcare changing and a lot of these groups consolidating into these large contract management groups, you just have to understand that if you're going into a super group, they tend to have very standardized contracts and you might have less room to negotiate. In addition, for thinking about who your employer is, if your group contracts, for example, as hospitalist contract with a hospital, even though you may want to negotiate your contract with your specific group that you're being employed by, it may also be limited by a hospital will only accept certain types of contract. So your group won't allow you to negotiate certain factors because of the hospital contract. And finally, if you come in as an employee of a group, you will, especially if you're coming into a group that you may want to one day join as a part owner, you want to see if the contract addresses and allows for future ownership opportunities and what the pathway is into that. For example, if you need a certain amount of time with the practice, buy-in, what the paid grade differential is. So just ways to know what your employer is, how does that affect your ability to negotiate your contract, and then whether or not you can change up what your practice option is.
One thing I might mention there too is with this idea of sort of bigger employers, which we do see more and more now, you might be tempted to assume that because it's an agreement they've used hundreds of times, that it's very good. And that is not always the case. So I've seen contracts that clearly have nothing to do with the jurisdiction, the physician who that agreement is being used with. It doesn't make sense, it doesn't comply with state law, or it just hasn't been like edited and revised in 10 years. So you'd like to think that those big groups and big companies kind of know what they're doing, but that goes under the, don't necessarily assume that piece because it's not always the case. Okay, next we're going to talk about, I'm briefly going to talk about physician compensation. So on my end, I was just going to mention that obviously that's one of the main things you want covered in your employment agreement. And there are lots of ways physicians are compensated, and they can be very complicated. So you want to understand them, and again, make sure that your understanding is memorialized there. So, if there was an incentive-based bonus, moving expenses, a signing bonus, whatever it is, you want all of that compensation included in your agreement. RVUs, which I think Dr. Wu will talk a little bit about, can be complicated, and you just want to make sure you understand the basis on which you are going to be compensated, how it's calculated, when it's due, how long do they have to pay it, some of those, essential terms.
Yeah, so I'll try to break down a little bit more of this complicated compensation issue. So like Anisa said, it can get very complicated. Now, in general speaking, there's 2 types of models a contract can have. One is a fixed compensation. So that's where you get a set salary. You don't worry about anything else. They tell you a number, that's what you get. And oftentimes that model is used for new physicians. And the second one is called a variable compensation model. So that's when the really complicated stuff comes in. That's when they use a lot of different formulas, accounting for your performance and determining the salary. And oftentimes they'll have more experienced physicians take this type of compensation model, and they prefer that too because they know their level of productivity. Now, that means that you may start out with a fixed compensation that then after a few years transitions to a variable one. And as to make things even more complicated, there's now sometimes a hybrid of these two. So generally with variable compensation, this is where you want to look at if compensation is tied to performance benchmarks. So these are like RVUs, right? Your productivity, your billing, or your collections. Collections and billing being the money you actually bill your patients and you're able to get that money back, in which case the payer mix of your community is going to affect your income because some payers just will naturally have lower collection rates. So those will be performance benchmarks versus these days with ACOs, accountable care organizations, you can also have quality-based benchmarks. So like patient satisfaction or quality improvement measures. And actually with COVID, a lot of these companies are realizing, or groups are realizing, that they need to have more flexible ways of looking at compensation since productivity changed so much with COVID. So in the end, actually, unfortunately, all I can really say still is that it's complicated. The ways that you can manage it is that you can reach out to your local medical society that you're going to go to, like, for example, MSDC here in DC, and they can help you understand that the offer you're receiving, does that meet, beat, or fail to measure up to the rest of the market? Because most of the time what you're trying to look for is a fair compensation, right? Just something that will match the market. And especially as some of these formulas get really complicated, you can ask the organization that you're going to, their financial officer, to tell you how each compensation, each component factors into a paycheck, and then give you an actual number of like the total compensation paycheck over years, what could it potentially look like? So just a couple strategies to manage something that is actually a pretty large topic.
Sorry about that. Okay, so next we'll talk about benefits. Again, this is something that some people, assume or, believe will be included. You want to make sure that it's in the agreement itself. This is also an area where a lot of employment agreements will refer to other documents. So an employee handbook, some other policy or procedure. But here are some of the benefits often covered in an employment agreement: your paid time off, health, dental, or vision insurance, retirement plans. Are they going to pay your continuing education costs? What other business expenses might be covered? And in that, you want to know, how is it covered, right? So sometimes you'll have an allowance for continuing education. Sometimes the employee covers it. Sometimes the employer covers it outright. There might be a maximum amount, there might not, but all of those benefits should be covered. Often it will say, almost always it will say, that the benefits can change time to time. So you do want to know in year 5 and year 6, pay attention, because the benefits under your agreement may have changed. And the main thing to look for there is, sort of as Dr. Wu was referencing with your compensation, is you ought to have benefits that are similar to other similarly situated employees. So full-time employees, or how long, people have been with a practice, however they monitor that, that should be, your benefits should match those in the same group.
And just one specific thing I want to highlight and remind people of, as my fellow residents, maybe like me, are waiting until after residency to start a family. So something that you want to be sure to clarify is maternity and family leave. So technically under FMLA, we are allowed to have 12 weeks of unpaid leave for family leave, but that actually technically only applies to companies that employ 50 or more people within a 75-mile radius. So back to looking at what kind of group that you're entering. If you're entering a small group, the FMLA might not apply to you, and you'll want to be clear about your maternity and family leave in your contract.
Malpractice insurance. So that's another area that I feel physicians can get a little tripped up on. There are lots of different products on the market, but the two main things that you would focus on are what type of policy is going to cover you. Is it an occurrence policy or claims made? And that really has to do with, is it when the incident occurred or is it when the claim is actually made? So that's one piece you want to know. You want to know how much the coverage is so that you know what kind of exposure you might have. For example, in Virginia, where we have a medical malpractice cap, you would want to be covered up to the cap, which leaves you with, no personal exposure in most cases. So you want to know what the coverage is, what type of policy it is, the amount, and then the tail and nose and who pays has to do with if it's not your first job and you're moving from somewhere or to another place, who's picking up those claims, right? So if I'm with Dr. Smith today and I'm moving to Dr. Bob, when I go to Dr. Bob, who's going to cover if there's a claim that comes out of that first job I had? Tail insurance is generally thought to be pretty expensive when it's bought in the market by an individual provider. Lots of groups will pick that up. And my understanding, I'm not an underwriter, but most physicians say it's a lot less expensive when one or the other group tax it on either on the front end or the back end. But a physician can also purchase that insurance, himself or herself. There are also risk retention groups and self-insured. You just want to be careful about that, right? Those are entities that basically manage their own money and their own claims. And so they may not go through the same underwriting scrutiny that more traditional insurance companies do. But obviously you want to make sure that you have malpractice, that it's part of your agreement. It usually is. And then you just want to understand the terms of that. I think next we're going to talk about moonlighting, which of course is what you may or may not be able to do outside of your employment or employment agreement. And that can include things like volunteering, expert witness, research, intellectual property. This I see in a variety of ways. Some employers preclude it without their prior written consent. Others say you can do it as long as it's not in competition. So it really just depends, but you want to understand what's permitted, what's prohibited, and if there is an approval process, obviously to make sure you do that before undertaking some other employment. Next, I was going to mention restrictive covenants. This is one I get a lot of questions about. So one thing Pia and I were discussing before the presentation is this is always a difficult issue because when you're starting a relationship and starting in employment, you of course want to think it's going to go swimmingly and everything will be spectacular and you'll never have a problem and that none of this will ever apply to you. And then one day you will decide to leave or they will decide you're going to leave and then you call. And now you're looking at your agreement and realizing you have a problem. So this you want to be very careful about because generally they are enforceable. There are some caveats. It depends on your jurisdiction. DC has toyed with the idea of making non-competes not enforceable, but we're not there yet. Virginia, certainly they are, and Maryland, they are. So you do need a state-by-state analysis of what applies to you when you sign your agreement and when you're going to be employed. But know that they can be enforceable and they can change the course rate of your career. If you've stayed somewhere for 10 years and your non-compete, it has a 10-mile radius, your life, could change significantly. So do pay attention to those, understand what they mean. And I usually caution people, don't sign it unless you can live with the terms. So don't think, they won't be enforceable or they won't come after you or after a few years you'll renegotiate. If that's an issue for you, if that is a deal breaker, then don't sign on to the non-compete. One of my other least favorite clauses that I see in a lot of agreements now is this idea where when your employment terminates, you're automatically going to relinquish your privileges. Again, I personally wouldn't sign an agreement that had that clause. Lots of physicians do. Some live to regret it. But I also have a concern. A lot of those agreements will say the resignation itself is, not reportable and it's not going to be an issue. But the other person on the other side of your agreement really doesn't determine that. they might determine they're not going to quote unquote report you, but that doesn't mean that for the rest of your life, every insurance form, employer, jurisdiction, licensing entity is going to ask if your privileges have ever been relinquished. Your answer will be yes. Now, your answer will be yes, it was part of my agreement, but it still means you're going to have to go through that process. And I don't like the idea of giving that much control over to your employer before you even get started. You know, if they decide to downsize, you know, your privileges are gone, or a million other reasons that you can't always predict or anticipate. So that clause concerns me. They usually talk about confidentiality, non-disparagement, and then of course what happens if there's a violation. Some of the more aggressive agreements will have a clause that says, you know, we agree that the damages are difficult to calculate. So if you violate it, you owe us $50,000 or whatever it is. You know, I'd say more agreements have that open, but some do have the actual, you know, penalty for the violations in the agreement themselves. So another sort of major issue I think you want to pay attention to before you sign the dotted line.
We'll talk about this a little bit more later on a slide on terminations, but even if you think, oh, this is my dream job, I'm going to sign it, I'm never going to leave, what you can realize is that a lot of hospitals and practice groups will actually have termination without cause, as long as they give you a 30 to 90-day notice. So you could say, I'm all in, I'm going to stay at this job, but you could get terminated by your hospital, and then your non-competition clause will kick in. And if you don't be careful about what extent of a non-compete you agree to, they could say for the next 2 years, you cannot practice within a 50-mile radius, which is really going to limit your ability to stay in the area that you want to be in. And so a lot of times, you know, I've read that they recommend to try and either remove these types of clauses or at least minimize the effects. For example, for the non-compete, if you have to sign a non-compete, say, I won't practice at this specific hospital, but not agree to like a mile radius.
Next, we're going to talk a little about the employee obligations under the agreement. Again, it usually will specify what the duties are, whether you have a certain volume or a certain schedule, or, you know, how many hours you're going to work, what your PTO looks like. It'll talk about incentives, how your formula looks. And as Dr. Wu mentioned, you know, is it collections, is it receipts? And that's how the contract will typically discuss the employee, and then we'll talk about the employer obligations as well.
Within the employee obligations, there's again just a lot of details here that you should clarify. One of, you know, including like administrative or teaching duties, your call schedule, whether or not you need to maintain certain certifications. So there's just a checklist that you should go through. A couple of things that I want to highlight. One being your expected patient and procedure volume, and ensure that this expectation is reasonable, because sometimes also your incentives can be tied to a certain level of volume. And I saw some stories from physicians that looking back, they said, wow, I realized that the incentive that they offered looked good, but it was tied to an unreasonable volume that could never be achieved. So you want to make sure that whatever they set out in your obligations, that you, again, reach out to mentors in the area, to physicians who have experience, and see whether or not that's reasonable. And the second thing I really want to bring up in our forever changing practice environment is if you have an obligation in supervising and signing the charts of advanced practitioners, and what liability you have for it. So all of us at some point in time in our career are probably going to be responsible for working with and overseeing APPs, and you know, you can be liable for what they do, and I would make sure that this is very clearly specified in your contract.
That's a good point as we move to employer obligations, which typically involve some of these things. You know, they'll provide the equipment, the supplies, staff, billing, your benefits. One of the things you see with those, like what I call them mid-level providers, is, for example, your employer may decide to hire and fire them, but yes, you might be responsible for overseeing them, for co-signing. So that is an issue that, and I would say it's an issue you should try to address, and it is evolving. So even if in your initial employment agreement, those things aren't specified, again, as that changes, let's say in year 2 or year 3, you do want to have something in writing where you understand what your obligations are and what the employer's obligations are, so that you're comfortable with it and it seems reasonable. Next, we were going to talk about the duration and termination and what I hope is due process. Employment agreements do typically talk about the term of the agreement and then how it is ended. So typically, there are lots of ways it can end, and you can be terminated usually either automatically, for cause, or not for cause. And yes, the not for cause piece, as Dr. Wu said, can be, you can be fired for any reason at any time with very little notice. So you could be doing a great job and it has nothing to do with that. So those are there. One thing I usually encourage people, if they're, whatever is good for the goose is good for the gander. So if it says your employer can terminate you with a 90-day notice for no reason, then you should be able to do the same thing. And a lot of employment agreements, right, are not necessarily written that way. So you do want to understand, again, you're going to go into it hoping you never need these clauses, but one day when you want to move, or you've been offered another great position, or things at the practice have changed and you don't love it, or whatever it is, you want to know how to extricate yourself. Again, one of my pet peeves, I would not waive a hearing. I would not waive due process. There just is too much writing on it. And you think that would, won't matter because you're never going to cause a problem. You're never going to have an issue. And so you think you'll be fine. But I would encourage you to not waive rights that you otherwise would have. And then, as I mentioned earlier, it's also a problem when there is this link between your employment agreement and your privileges. And regardless of what your employer tells you, there can be reporting requirements either to the data bank, to a board of medicine. The other thing I would say here is it really doesn't matter that Joe Blow, who drafted your contract, said he wasn't going to report it. When the termination comes, if they consult their lawyer and their lawyer says it's reportable, then you're getting reported. So, I would not rely on those sort of promises very much.
And I want to talk a little bit more about this issue of due process. So, on this next slide, you'll hear about this case. Maybe some of you have heard of this. It was an ER doctor early on in the COVID pandemic. He was criticizing his hospital's handling of the pandemic, granted publicly, he was posting on social media, but also sent a letter to the CMO. And actually, as a result of it, was told that the higher ups were not happy with him, and then he just lost all of his shifts. And this was without him having any kind of prior notification or any opportunity to have a explanation of what happened. So with due process, what we mean with that is like fairness in dealing. So fairness of the means to implement the criteria for taking action and making decisions. And the JCO and Healthcare Quality Assurance Act of 1986 requires hospitals to give physicians appropriate due process. But the issue is that sometimes you can waive it in your contract. So this is like what Anisa was saying, don't waive due process, because in those cases, then not only can you be terminated without cause, but then you won't have any opportunity to either fight it or explain yourself. You'll just be like, unfortunately, Dr. Ming Lin, who just had to move on to finding a new job because he just lost all of his shifts and then had no further opportunity to discuss why that happened.
Okay, next I was going to cover just some of the boilerplate language, which is really sort of the, less exciting legal stuff. Assignment, we talked about a little bit earlier. Amendments is where the agreement can be altered, and it usually is over time. Which law governs? So if there is litigation or there is an issue, do you have to arbitrate according to certain rules? Do you have to litigate in a certain jurisdiction? Most of them talk about severability. Whether you've waived any rights, do you have to go through mediation or arbitration, or electronic signatures? Okay, what other pieces of the agreement are there. So at the end of most agreements, there is this boilerplate language, and you just want to make sure you understand it and sort of what the implications for you might be. I think Dr. Wu was going to talk about one of the major issues.
Oh yeah, I'm going to expand a little bit on the force majeure. Again, I feel like I'm over here being like, post-COVID, everything changed.
That definitely is a major change since COVID.
Yeah, exactly. So here I am once again saying that COVID has significantly changed our practice environment, and force majeure is something that's coming up in contract provisions a lot more. So it literally translates to an act of God, which essentially says that due to an unanticipated catastrophic event, like COVID, for example, if this is in your contract and they can say they can suddenly alter significant portions of your contractual terms purely because they say, unanticipated catastrophic event out of our control, we're just going to have to alter your contract, even though we had signed and agreed upon something before. So again, this is something that we've seen coming up a lot more in the post-COVID era, now that employees are realizing that something catastrophic like COVID can happen, and they might still be obligated to pay physicians when they have lowered productivity. I don't necessarily have a solution to this. It's just something to look out for, that it's going to be coming up more in your contract.
Agreed. It's definitely something to be aware of, and it wasn't anything we saw, 5 years ago, and now it's pretty common. Next, I was just briefly going to talk about negotiating strategy. Obviously, you are beginning a new relationship, and yes, you want to have some trust on both sides. No agreement is going to cover everything. And even if it does, there will always be enough wiggle room, right, or ways around it. So it's never 100%. But you do want to have a good relationship and be trusting. But at the same time, you do want to have your eyes wide open and be looking at worst case scenarios. So yes, you want to hope that everything goes well, but you also want to understand what happens if it doesn't. And that's when the importance, right, of having it in writing will be an issue. And the other thing I tell people, physicians often ask me, can I ask for this, or should I ask for this? And the only thing I can say about that is you will not get what you don't ask for. So if it's important to you, then yes, you should raise it. The worst they say is no. I don't know. Do they think something of you? You're a tough negotiator. You're, a harder sell. That's okay. I mean, this is a job that you're going to devote a lot of time and energy to. So if something's important to you, then you need to ask for it. Otherwise, it's just a bad way to start. Next, Dr. Wu is going to talk about physician unions.
All right, this is just a little something I added in. I don't want to go too much into it because an in-depth discussion is out of scope of this talk, but just in the idea of talking about negotiating strategy. So the AMA, actually, the American Medical Association, supports the right of physicians to engage in collective bargaining. And they say employed non-supervisory physicians actually do have protections from the National Labor Relations Act. They have an exemption from antitrust laws and can participate in union concerted action for negotiating for their employment. So the overall number of physician union members in the U.S., only 7.2% of actively practicing physicians. So a relatively small number, but that number has actually, I don't remember the exact, I think it's doubled within the decade. So there's definitely increasing interest, especially for physicians to have more negotiation power in collective bargaining and for the prevention of burnout. So if you are going into a specific market, I would just look and see whether or not there is an existing physician union there, and is there any existing collective bargaining agreement that you can use to help with your negotiation. Here I just have some additional resources. Of course, we've covered a lot today. This is not necessarily a comprehensive talk, and also, again, not specific legal advice. So there's still going to be a lot of other resources out there for you to take a look at. So Perla Academy, who is supporting the MSDC and giving this talk today, they have a really great guide to physicians' employment agreements. I believe Pia sent this out. It essentially follows the format of a contract with each sections listing all the common provisions, so that way you have your checklist and you don't miss anything. In addition, most of our specialty organizations are really great about giving us specialty-specific advice. So the, American Academy of Family Physicians, College of Physicians, for my own emergency physician, most of them have a website detailing some information. Like the AFP, they have a special employment contract section on their website that you can look up, where they have a family physician guide to employment contracts, so specific to family physicians, and a negotiation letter template. And then the ACP, they have this contract guide that I looked through, that they have some really useful tools in there. They have this like self-assessment tool you can plug into to determine what your practice preference would be, and also a worksheet that you can use to help compare offers as the formulas get complicated. And then finally, there's the New England Journal Career Center. They have a lot of detailed articles, including on like the nuances of compensation that I said can get very complicated. So if you want to do more of a deep dive into things, you can look at some of their articles. But I am happy to reach out to Pia and send some of these resources along to you as well. All right, so I think, in summary, Anisa, thank you for being here with us. And I think, please add if you think there's anything else, but I think we just want to say, know the details of what you're signing, get help from an expert because this can get complicated, have a checklist, and don't be afraid to negotiate, although knowing that you likely won't be able to go line by line and negotiate every single item. So we'd like to open this up. Thank you all for paying attention and being here with us tonight. Any questions that we can specifically answer for any of you? And if none of you have any specific questions, or you can take some time to think about it and put in the chat if you don't want to speak, I'm just going to ask Anisa a couple questions. So first is, like you said, you can feel a little awkward going into the negotiation because you feel like you're just starting out with an employer. You want to build a relationship. So if there's some points that you don't feel confident negotiating with them, is it acceptable for you to have a lawyer negotiate with their lawyer? Say, my lawyer is going to reach out to your lawyer.
You certainly could. There's no reason you can't do it. I would say in my experience, most physicians sort of like the help on the back end to prepare them so that they have the points or issues that they want to raise. And then usually they will raise it with the employer themselves, and the employer does the same thing and goes to their attorney. So yes, you could negotiate it attorney to attorney. That's no problem, but it's not typically the way it's done. I think just, I want to say history, right? I think it's just people do it the way they've always done it. And so it tends to be employer, employee who actually have sort of the meaningful conversations. But I definitely have clients who, as they negotiate, will say, does this language sort of cover what I wanted? What do you think about this? So it's usually more behind the scenes, but I have negotiated them outright, and there's no reason not to.
Perfect. We also have a question from Nisha. So she wants to know, what should you ask for, negotiate in an offer letter versus the contract?
Dr. Wu, you might answer the offer letter better. I will say I don't see a lot of those. And when I do, I don't want to say the ones I have seen are not very meaningful, meaning they don't have a lot of terms, there's not a lot of detail, and it typically says sort of to be determined, to be discussed, to be evaluated. So I don't see a lot of offer letters. Typically when something comes to me, it is, now there might be like a term sheet that then, develops into an agreement, but when I'm involved, it typically is the, 10, 20-page employment agreement document.
My understanding with the idea of the offer letter is that, again, oftentimes it's non-binding, also depending on the state law that you're dealing with. But in general, it's something that's very broad, just kind of shows their interest, maybe gets a little bit into the compensation. But when you really start negotiating, that's for the details within the contract, because you really don't want to negotiate the offer letter or try to sign on anything to the offer letter. You want to get all of your negotiations and all of your wants and details into your actual contract, which will be following you forward. Great, thank you for that question. I hope the answer helped you. Any other questions that we can answer? Because if not, I also have a couple more to ask Anisa. So I think a lot of us, obviously we're coming from all different places and we may end up going back to all different places, but I know a lot of residents will tend to practice in the area that they did their residency. So for us, that'll be in the Virginia, Maryland, DC area. Do you know if there's any, specific nuances in Virginia, Maryland, DC law just that are very different that we should be aware of?
There definitely are. So each of those jurisdictions is very different, right? In Virginia, there's a medical malpractice cap. There are not in the other jurisdictions. How they enforce non-competes are different. In a hospital, your due process rights will look the same, but in any of those jurisdictions, otherwise, they would look different. The boards that govern them are very different. I hate that it's recorded, but I would say Virginia and Maryland are much more organized than the DC board. So there are definitely some nuances there. And then, of course, the geography matters, right? As I said, if you're practicing at GW and you can't practice within 10 miles, so that it eliminates Georgetown, GW, whatever else is in that radius, that can be a pretty significant change. Same in Northern Virginia. If you're going to go with Inova and there's a non-compete from any of their facilities, that starts eliminating a lot of areas. So definitely the jurisdiction matters, and there are some idiosyncrasies or differences in those jurisdictions.
Perfect. And we have a follow-up question from Nisha asking, so then should we get a lawyer from the area your contract is from so they understand the local laws?
Well, mostly you probably want a lawyer from where you are. So if you're going to practice in Virginia or DC or Maryland, you want a lawyer who's licensed in that jurisdiction to review your agreement and contract. Now, they will look at it like I did have a physician recently in Virginia. I think I reviewed her agreement, and it proposed that her contract was going to be enforceable in New York. And I was a hard net, right? There's no reason for a Virginia doctor who's practicing in Virginia to subject herself to jurisdiction in New York, where she has no tie and doesn't practice. That might be where their head conglomerate office is, but there's nothing in it for her. So she had a Virginia lawyer review her Virginia agreement, and that was one that didn't have, some of the clauses weren't even appropriate for the jurisdiction. So probably where you practice is where you want one.
So I guess I have a follow-up question to that, where a lot of residents may be looking for jobs in different areas of the country. So that could potentially become pricey and add up if they're getting a lawyer for, for Seattle or a lawyer for Chicago.
Yes, that's probably why I see it, right, when there is this contract that I'm thinking of, right? And you're exactly right. So I do a lot of resident contracts, actually, for a variety of reasons. And usually what will happen is they will entertain offers from different places. And then once they have a first choice or a preference or a leaning to something, then that's when we'll talk about their employment agreement. Now, some do end up, not going with that position and we'll take another one. But I think at that point, so many things are in common that then even if we only look at one, I think a physician can kind of take that information and apply it to some of the other agreements that they might be looking at.
Okay, so we're coming up to the end of the hour, and of course we want to be respectful of everyone's time. I'm happy to take one last question if anyone wants to type anything out, but I'm going to turn things over to Pia to close out the session.